Uh, Thank you. Good afternoon, Judge Smith.
Good afternoon, Chief Justice and Commissioners.
How are you this afternoon?
I am fine, thank you. I trust you and the Commissioners are also well.
Yes, we are all
Thank
very
you.
well. Thank you. We interviewed you not so long ago, so you are familiar with the rules that we follow when we interview candidates. So I won't repeat them, but basically we will ask you questions
Can't hear anything.
to satisfy ourselves whether you meet the selection criteria that we have adopted for the appointment of judges to various courts. But before we proceed, I must thank you again for availing yourself
Yes.
for consideration for appointment to the
Yes.
SCA and for coming to this interview. Thank you very much.
Yes. Thank you, Chief Justice. It's an honor to be here again.
Thank you. We have a lot of information that you have supplied us with in the questionnaire and in other documents. We will not seek to cover everything, but all the information before us will be considered when we have to make a decision. So in questions, we will simply focus on certain areas only. I will ask some questions, then I will allow the president of the SCA to ask questions, then the minister, and then commissioners.
Yes.
In terms of your academic qualifications, you hold a BA law degree, LLB, and an advanced diploma in labor law, is that right?
That is correct, Chief Justice.
Yes. And you were admitted as an attorney in 1984, is that right?
That is correct, Chief Justice.
And you practiced as such until you were appointed to the bench, is that correct?
That is correct. That was in I think
2010?
in July 2010, yes, Chief Justice.
Yes. So that had been about how many years?
Without the acting stint, which had been recognized, it would be 14, just about going on to 14 years. And then obviously when the acting stint is taken into account, it would be 15 years.
Yes, no, but I'm talking about the time that you spent in private practice from
Oh, sorry, in private,
1984,
yes, that,
1984 to 2010. How many years
I think
was
it was
that?
about 26 years.
Okay,
Yes.
okay. And during that time, of course, you did a lot of human rights work, is that correct?
Yes, that is how the
Yes.
firm started out, Chief Justice.
Yes. Apart from that, what other branches of law did you get involved in your practice?
Yes. For the first, I would say almost for the first 10 years, it was mainly human rights work. Criminal matters, which were mainly defending politically charged persons, and administrative law, challenging validity of regulations and enforcement of regulations, and urgent applications to interdict assaults on detainees, trying to get detainees released, and those type of matters. And then I think it was in 1990, 89 or 1990, when the then Ciskei government adopted a constitution which incorporated a justiciable Bill of Rights. We did quite a bit of constitutional work at that time a number of cases where we challenged the validity of laws which allow detention without trial, but blanket bans on meetings and those type of things. Of course, with the advent of things changing in 1992, the character of the firm also started to change, and we linked up with another firm. And from then on, the firm did commercial work, property work. It had quite a large component doing conveyancing. And those type of issues, contractual work and those type of issues that then started to develop. I had also, by that time, did quite a bit of labor law, but I must confess that the labor law practice never really took off. I was always involved more in other type of matters as the firm grew. But it was quite a mixed bag of matters that we dealt with. I must say that my interest and my speciality remained in the area of administrative law. Of course, representing a number of municipalities in the areas, and then also certain government departments as well. So it was the procurement law, administrative law, those type of cases mainly at the time.
Okay. And then as a judge of the High Court, in what branches of law have you written judgments?
Yes. In a varied field, Chief Justice, if you just allow me to explain that because of the unique layout of the...
I'm sorry. I wouldn't like you to explain it. I would like you to simply say, I've written
Yes.
judgments in commercial
Yes.
law, patent law, insurance
Yes.
law, whatever law. So I just want the branches of law
Yes.
so that the commissioners can see the breadth of your experience.
Yes, yes. I was just going to explain in all the areas in the Eastern Cape courts and the certain divisions, the type of matters that you do, but I take
I
your
don't
point.
want that. I just want you to tell me the branches of
Yes.
law.
No, I accept that. Of course, there's criminal, the criminal law. There's a constitutional law. I wrote 2 judgments where the validity of provincial laws were challenged. There's procurement law, property law, other areas. When I sit in Kabeja, there's usually quite a bit of commercial law, contractual law, the straightforward liquidations that we have to do. And those are really the type of matters where I have written most of my judgments, Chief Justice.
Yes. And you have acted in the Supreme Court of Appeal as well.
Yes, I did.
And did your acting stints in the Supreme Court of Appeal expose you to other branches of law to which you have not been exposed at the High Court level?
Yes, yes, it did, Chief Justice.
And tell us which branches of law it exposed you to.
Yeah, in particular, in the field of tax law, mostly involving duties, import duties. There's a number of matters I had occasion to write a judgment on that particular issue. Of course, there was procurement law as well, but in a different context. I had occasion to sit on matters involving the competency of the JSE to impose obligation on companies to restate certain information on on their financial statements. I'm just thinking now. I have recently had occasion to write a judgment which involved criminal law, which surprisingly enough, having done quite a bit of criminal cases in the High Court, it's a matter that I never had to deal with, but that involved the question of reservation of questions of law, in which I wrote a judgment that was, I think, just about delivered 2 weeks ago. Yes.
Yes, and may I now refer you to your questionnaire, question number 16.
Question number 16.
Yes.
Yes. Yes, I've got that, Chief Justice.
Question number 16 says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why.
Yes.
And you have referred us to Annexure A,
Yes.
which appears on paginated page 18A, capital letter A. Are you there?
I've got it, yes, Chief Justice.
Yes, the first case there, SA versus JHA, it's a Supreme Court of Appeals judgment. But when I look at the narration that comes under it, it seems more like what you will get in the heading of a judgment in the law report than you telling the commission why you regarded the case as significant.
Yes. Yes, I did that for the sake of brevity, Chief Justice, and maybe I could have been more descriptive. But I thought that because I also annexed that judgment that it would capture the essence of why I thought it was an important case in the context of other cases that I dealt with.
Yes, I think you adopt the same approach
Yes,
with most, if not all of them.
yes,
And for example, number 3, it's where you're supposed to say why you regard it as significant. You say pension fund rules, amendment of rule governing withdrawal benefits so as to reduce such benefits, amended rule, retroactive effect, validity of rule, held that the rule was of retroactive application and that the presumption retroactivity against retroactivity was rebutted by the funds, clear intention. So that's the approach you adopted, but you concede that it doesn't make it clear as one would have preferred to say,
No.
this is the reason why you regard it as important.
No, I accept that. I could have been more explicit in my reasons and added a bit more description.
Yeah.
But as I say, I just thought for the sake of brevity, but I take the point, Chief Justice.
Yes, thank you. Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, Chief Justice, the Constitution allocates and delineate the constitutional responsibilities and obligations of the 3 spheres of government, being legislature, the judiciary, and the executive. And the Constitution provides that the one sphere should not encroach or impose on the sphere of the other sphere of government. The issue becomes particularly pertinent when it comes to the judiciary, because it's the judiciary that has to declare the law, and it is often the judiciary that is placed in this dilemma as to whether or not it should it should grant an order that could possibly encroach on the area of particular of the executive, for example. So, but that is basically the principle. It is essentially deference for the constitutional responsibility and power of another sphere of government.
And rule of law?
The rule of law is one of the founding principles of the Constitution, Chief Justice. It is mentioned in, I think, Section 1 of the Constitution. It is a principle, it's almost a universal principle that says that everybody is subject to the law, and in particular, including organs of state as well, that they must be held to account for acting in terms of the powers that have been granted to them in terms of the Constitution.
Thank you, President of the SA.
Thank you, Chief Justice. Good afternoon, Justice Smith.
Good afternoon, Madam President.
You have acted at the SCA for about 4 terms, am I correct, or is it more?
Yes, I think it would be more. Now, I think this is my 5th term, Madam President.
Oh, okay.
But it wasn't continuous. As you know, I acted, I think, last in
Yes.
2023, and then I again this year from February been acting in the Supreme Court of Appeal.
Yes. How was the transition from being a judge of the High Court to being a justice of the Supreme Court of Appeal?
Initially, the learning curve was quite steep. I think what made it worse for me is that unfortunately the first 2 stints, 2 terms in the Constitution was during the COVID period lockdown. It was during hard lockdown, and we did everything virtually. So I couldn't have the benefit of interacting with my colleagues. And then fortunately, there was a bit of a lifting. So during the 3rd term, I went and came to Bloemfontein and then was able to interact. But it was challenging because it is very different from how we work at the High Court. The way in which judgments are being written in the Supreme Court of Appeal is different. The fact that there are invariably 4 other colleagues that you have to work with and get their buy-in into your way of thinking, and also make contributions to their judgments as well. So it was initially, but I managed to find my feet quite quickly, and speaking under correction, I was able to deliver all my judgments within time. And I don't think there was any complaint of any delays on the part of the judgments. I was also able to prepare for the hearings, to read the records and come prepared and able to make a contribution both in court in terms of putting questions to counsel in order to elucidate issues further and to make issues clearer, to understand their arguments. And during the post-hearing conference, I was able to make contribution and made some input on the judgments of others as well. Although these were, to be honest, mostly sometimes cosmetic and sometimes just a suggestion that maybe we can deal with this case as well. But as I say, in the end, towards the end of the 3rd term, I felt more comfortable, and I felt that I was beginning to enjoy myself, and there was a bit less stress. Yeah.
Yes. But you'd agree that in these 5 terms that you have acted there, that the one thing that is consistent there is the enormous workload. I mean, the pace is just relentless. You agree?
Yes.
Yes.
Yes, certainly, Madam President. You'd recall that in February, I think I was given, I don't want to exaggerate, but it was about 2 or 3 weeks notice of the acting, and I think I got the records about 2 weeks before the time. I was at the time engaged in a criminal trial in Grahamstown, and you quite graciously agreed to allow me to finish that trial before I started my acting appointment. But in the end, it meant that there was tremendous pressure on me to prepare myself, to read all the records, to prepare myself. And then I had 3 judgments to write in that in the first term as well. So the workload is daunting. The pressure, as you say, is relentless, and one has to just make sure that you stay up to date. Otherwise, you're going to sink if you don't swim.
Yes. So you agree that a strong work ethic is crucial?
Absolutely.
Yes. Now, you are probably aware that the Supreme Court of Appeal has lost a lot of experienced judges. Some have retired, others have been elevated to other courts, and there is therefore a need to complement the existing expertise with strong candidates, if I can put it that way.
Yes.
Candidates who will be able to hit the ground running and not rely on any kind of hand holding, be able to work independently and basically be self-reliant.
Yes, I realized that. One of the senior judges took retirement during my first stint, and I know that the Supreme Court of Appeal has lost a lot of experienced judges, and it is imperative that there are people who are able to, whoever comes in must be able to, as you say, hit the ground running. And then, yeah, I understand that statement,
Yes.
Madam President.
I note that you have been a judge for 14 years now, and according to my calculation, your experience prior to appointment to the bench is about 28 years, which gives you about 42 years experience in the legal field. Is
Yes.
that a fair assessment?
It is a fair assessment, Madam President.
Yes. So what are special attributes that make you the right candidate to be considered for appointment at the Supreme Court of Appeal? What will you bring to the table? What will you contribute to the skill set and the experience that is required there?
Yes. Madam President, I think I've shown that I work hard. I make sure that my judgments are ready for circulation as soon as possible. One of the judgment was literally a week after the hearing, the judgment was circulated. And it was during the time when, as you know, we've struggled with getting any type of assistance from the researchers. So we had to do research ourselves, a huge challenge. And I've been able to do it. I've made contributions, as I said. I do think that my background in law, in particular in constitutional administrative law, it enables me. I'm not going to say that I can walk into any type of case without preparation, but it has enabled me to discern in any type of matter, whatever you call it, if you call it tax matter or any other type of matter that I just cannot think, any branch of the law, that I am able to discern the legal principles that are applicable in that type of matter, and that will have to be resolved in order to dispose of the list between the parties. So I have been able to understand issues in matters that I have not dealt with before. I've mentioned, for example, issue relating to a dispute between the JSC and a listed company. I've never dealt with that in the Eastern Cape. But one gets to the point where you can go in and you identify the legal issues that lie at the core of those, because often you find that you deal with terminology, strange terminology, but when you break it down, it comes down to certain legal issues, but it's hard work to get there. But I think I'm a team player. I get along well with my colleagues. It's been like that in the Eastern Cape, and I think I don't expect that you would have received any complaints from any of my colleagues about my inability to work with them or to defer to them, to listen to them and interact properly and professionally with them. So that is what I bring and I think I have shown with this first term now, having such a short period of time to prepare myself, that I've shown that I can hit the ground running, as you put it. So I think I'm ready, but it's up to you to decide whether that is in fact the situation.
Yes, you mean the JSC, not me personally.
Yes,
Thank you,
I
Justice
mean
Smith.
collectively, Madam President.
Yes, thank you, Justice Smith. Thank you, Chief Justice.
Thank you. Minister?
I've got no question, Chief Justice.
Thank you, Minister. Commissioner Marumohai?
Thank you very much, Chief Justice. Good afternoon, Judge Smith.
Good afternoon, Prof. How are you?
I'm fine, thanks, and you. I have a question for you, but for some reason, the judgment that I wanted to talk to you about, which is part of your panel,
Yes.
your bundle, but for some reason I cannot locate it. It's DVT versus BMT. It was a domestic violence case.
Yes.
It appears for the first time in page 14 of your bundle.
Yes.
I tried to locate it in the rest of your bundle, but for some reason I cannot locate it there.
Yes.
But I located it somewhere else. I'm not really sure if on your bundle you can be able to locate it. This was a case that dealt with domestic violence.
Yes.
And I understand that you don't have the act in front of you.
Yes.
And perhaps the question that I want to ask you, it might be somewhat unfair. Because and I think I agree with everything that you did in the judgment, except what I'm going to put to you now. In paragraph 10 of that judgment, you quote from, and I assume this is the Domestic Violence Act.
Yes.
You quote from the Domestic Violence Act, and you define emotional, verbal, and psychological abuse. And in the quoted part where you define it, A, you say repeated insults, then B, you say repeated threats, then C, you say repeated exhibition. I'm not sure if I have the old version of the act or not, because what I see from the version that I have, it doesn't seem that the word repeated appears there. So it was just a little bit something that was concerning for
Yes.
me, and I might be the one who's wrong. And it becomes unfair because you don't have the act
No, I
with you.
don't
But let me ask you a general question nonetheless, because that for me it's concerning as to where do you get the word
Yes.
repeated. Can a person be found to have committed an act of domestic violence which is not repetitive, that happened only once? Because when one looks at how the Domestic Violence Act works and how the Harassment Act,
Yes.
actually the Prohibition of Harassment Act works, where the courts have repeatedly said that yes, there might be a repetitive sort of conduct, but a single event can be so serious that even on a single event, a person can actually be found to have committed an act of harassment.
Yes.
So I just want to transfer everything into the Domestic Violence Act. Is it possible for a person to be found to have committed an act of domestic violence so that the remedies that are provided by this act can be applicable or the complainant can actually benefit from them?
Yeah. Not having the benefit of having the act, yeah, I would say undoubtedly so. I think the issue of repetition, and perhaps where an applicant may have to show repetition, is that certain conduct isolated incidents of conduct which may in itself not appear to be aimed at abuse or appear to be violent. If repeated, it can. We know that, you can walk past a person and touch him or her on the shoulder, and then it would be nothing. But if you do it 3, 4 times, then it is starting to look like you've got another agenda. So I would say certainly, and a single act can, and in most cases, a single act would constitute domestic violence. But the more innocuous, seemingly innocuous acts could also, if repeated, amount to harassment or domestic violence. I think that is essentially what I was trying to say. And it's in the context of that case where these SMS messages, that if you take the one in isolation, you think, this is nothing. But 2, 3, or 4 of them, then you're beginning to see a pattern, and then this is now harassment. So that is what happened in that case.
No, thank you very much, Judge. But my parting shot would be, if you do get a chance, please look at this repeated thing, because if I'm wrong, then everything is fine. But if I'm right, that word is not in the definition, then that means this decision might have created some challenges. But please look at it when you
Yes,
when you
now
have a chance.
I shall do that, and perhaps at the next conference where we speak again, I shall let you know, Prof.
No, thank you very much, Smith. Thank you very much, CJ.
I wonder what Judge Smith is eyeing for next time.
No, and I think a few weeks ago, we were speakers at the same conference.
I thought you said in the same forum.
Hopefully not, Chief Justice.
There is a position we hope to fill tomorrow in the SCA.
Yes.
Commissioner Nwachobbi?
Thank you, Chief Justice. Judge Smith, it's just to get some clarity. I have it from your CV that you acted at the SCA between October 2021 and May 2022. Is that correct?
Yes, I think
And then you
that is.
acted again between February 2024 and March 2024.
Yes, and now I'm acting at the moment, Mr. Nukaitobi.
Appoint. Now, in that period, which is roughly 10 months, you produced 4 judgments.
Yes, I think that excludes the 3 judgments that I wrote in the last term. I gave one of the judgments I submitted. There are 2 others which came after the deadline. So I wrote 3 judgments in the last term.
Yeah, I'm just talking about that period of 10 months.
Yes.
Of October 2021 to
Yes.
March 2024. That's 4 judgments.
Yes.
All right. Yeah, that's fine. Thank you.
Thank you.
Thank you. I don't see any other hand, and I've not been told there's any hand on the virtual platform. Thank you very much. We have come to the end of this interview. Thank you very much, Judge Smith. You are now excused.
Thank you, Chief Justice, and all the commissioners. Thank you very much.
Thank you.